You should have said, based on information available to you, you did not think there was any need, but you didn't say so. And the media out there, it made it seem as if the House just embarked on a wild goose chase without any foundation. And that is what we're choosing this opportunity to establish very clearly. And all the documents we're referring to, we will avail you of these documents. Like I said, the DSS is not an irresponsible organization. They responded to this matter categorically, talking about how they're going to look into the matter. The former Minister of Petroleum, Minister of State, made a correspondence to the National Security Advisor, another very high-level individual in the executive in Nigeria, regarding this particular matter. And like I said, finally, formal correspondence even from Mr. President himself regarding this matter was made. These are not irresponsible people, sir.
The exception I take arising from your position as well, Mr. Chairman, was the fact that Abubakar Malami, as the Attorney General and Minister of Justice, was being associated with the loss of $2.4 billion in the system. And I take that exception.
No, nobody ever said that.
That is what the press, apparently.
No. You see, that is what, so we understand your own disposition towards, but at no time, thankfully, did you hear this committee or anybody in the House say Abubakar Malami was involved in this? No, the House simply has embarked on an investigation about this issue and has invited you as the Attorney General, not even as an individual, as the Attorney General and Minister of Justice, because of allegations that you were part of that committee and you was also privy. And one of the reasons why also, and this is where I'm happy the Solicitor General to herself is here, is because certain individuals who were involved in making these allegations were sued based on what was said to be another petition from our own investigation. It is a faceless group called African Advocacy for Good Governance that wrote to your office about this issue, and then the Solicitor General in your office acted upon it and instituted legal action against these individuals. These were individuals that were also alleging this particular matter. So that is also information that we believe you are privy to. A certain petition by this Advocacy for Good Governance in Nigeria, which the CAC is not aware of the organization. We have done some search, we're not aware. So these individuals were alleging, like we always say, nobody is indicting anybody. We're trying to get to the facts of the matter. But this is also information that we got informed about. We invited Interpol, who confirmed that yes, they are aware that the Attorney General's office instituted action against these individuals. So we were wondering why certain action was taken against individuals who alleged something was stolen. We just wanted to be sure that Nigerian citizens were not being harassed unduly because they were trying to provide details of any sort of infraction. So I don't know if you're aware that your office instituted legal action against some of these individuals.
Well, with the mutual exceptions in mind, an exception on the part of the National Assembly, and indeed an exception on the part of the Attorney General of the Federation, I think we can now proceed on the basis of collaboration. And the basis and foundation for such collaboration is for the committee to make available what documents it has at its disposal, so that the Office of the Attorney General can as well review its archives, look into these documents, and then if there is need for developing any questions and answers as were the traditions that have been established, we can proceed on that understanding. But my major problem was the insinuations that has been paraded by the press against the person of the Attorney General, against my person as Abubakar Malami, and taking into consideration that assumption, that insinuation has not been displaced. I think we can now proceed to the business of collaboration for the purpose of investigation. Any investigation that has the capacity of bringing $1 to a Nigerian state, I will be a party to it, I'll be interested in it, and I will support it. Against the background of the fact that under my watch, The Office of the Attorney General has succeeded in recovering over $1 billion for the Nigerian state over time. So I have no problem with the committee, but I have problem with any insinuation suggesting wrongdoing against my person or against the person of the Attorney General or indeed the Federal Ministry of Justice as far as this issue is concerned. It's not about wrongdoing, it is about the ordinary course of business and execution of what we are statutorily saddled to do, period. So with that, Chairman, in mind, my suggestion is, arising from the questions put forward, which were around 30 or so, I responded formally. Arising from the question, from the request for documents, we have submitted documents, and then with that background in mind, if there is need for further engagement, with particular regard to the documents you claim to have at your disposal, my suggestion for the purpose of moving this process and the investigative functions, oversight of this committee is concerned, is for us now to collectively review the two. Review what is presented on my part, review what is available at your disposal, and then we agree at a middle course that can now advance the oversight functions of this committee. That, I think, is the better way and manner to proceed. Thank you, Mr. Chairman.
So, may I kindly So
you
I
can go ahead.
would like to refer the distinguished committee to serial 7, which was in response to question number 20, with reference to your letter dated 12th of January 2023. And the Attorney General, during the last meeting, informed the very distinguished committee that the Office of the Attorney General does not have investigative powers. We don't have investigative powers. And we confirmed that we did indeed receive a petition in the Office of the Attorney General from advocacy, from the NGO, which yes, sir. And what we simply did was to send the petition and attachments to the Office of the Inspector General. Perhaps if the Inspector General should have checked if they were registered before embarking on investigation, perhaps that question may be directed at them. We only acted on the basis of the report of the investigation by the Office of the Inspector General. It was on the basis of the report that we filed charges. We didn't take any action on the basis of the petition itself, sir. I thought I should provide that clarification.
Okay, so I appreciate the clarification. And just to also inquire, did you provide a copy of that petition in your submission?
Yes, sir. All the annexures were there.
Of that
Yes,
petition
sir. Yes,
from
sir.
the
As well as-
advocacy?
Yes, sir. Yes, sir. We did.
Okay, so basically you would respond this way to any petition that you receive?
Yes, I would normally, once we receive a petition, we just move to the appropriate security or law enforcement agency, police, EFCC, ICPC, depending on what the subject is.
Okay, so thank you very much, Honorable Attorney General. So to move quickly, with regards to that first aspect of the committee's mandate, peruse other details that we have in that regard, and then we will now expect your response to us in that regard. Now, the other aspect of the committee's mandate which you alluded to in your submission is the recoveries that have been made by the federal government till date. Now we have a submission which I would like for you to show the Honorable Attorney General. And for the records, we believe it was not absolutely necessary. Now, in their own records, in addition to what you provided the committee with, which we'll ask a few questions about, these are some recoveries that they say were also made. Unfortunately, we didn't make this available to you before today, but we believe you can respond to us too about whether or not you are aware of those recoveries and if they're also captured in what you have submitted to us, sir.
At a glance, I can say with confirmation that there are names that are of the beneficiaries in column 3 that are familiar. Others, I may have to refresh my memory over them, going back to the office through the archives. For example, Mr. Bashir Nasru and Co., I can confirm that there were recoveries effected and there were payments made for the recoveries made by the agents. That I can confirm. Mr. M.E. Sharif and Co., I can confirm that they were engaged by the Office of the Attorney General, not necessarily on account of whistleblowing, but on account of recovery, perhaps identifying certain public assets, either in the financial system or offshore, and then they are now profiled, they are engaged, and then upon recovery, and then confirmation of the lodgement of the funds in the asset recovery account of the central bank with a letter in support confirming the receipt. I now process to the office of the Minister of Finance for the payment of their professional fees. I can as well, in that circumstances, confirm the M.E. Sharif as having been engaged as employee. Before Opeshei, SAN, I can as well remember with precision that they were engaged. AOE Law and Associates, they were as well, by my memory, engaged among others. These are some that I can recall with precision. So these are some of the ones that I can recall with precision, that they were engaged, and then they have performed, they have recovered, recovery lodged into the federal government account, recovery confirmed by the central bank. Upon confirmation, their entitlement to professional fees were processed to the office of the Minister of Finance for payment. All others, I may have to refresh my memory by way of referring back to the office archives.
Okay, so thank you very much, AG, sir. Because, like you pointed out, you can identify some of them on the list, but in your own submission to us, you did not indicate them in your own submission.
It all depends
it's
on
It's only Digbo.
If your question, perhaps, does not itemize them, I may not necessarily factor them to mind. But what I'm saying with precision, whatever question is put across, if it is in any way tied to a personality, individual, law firm, or recovery agent, is certainly addressed. So if I have not indicated any of these ones, it's because you did not ask. And
no,
also,
yes,
my response for the purpose of the record relating to the questions raised was exclusive on the 48 million barrels of crude oil, because that is, by my understanding, arising from the name of the committee, arising from the assignment the committee is embarking upon, was exclusive on the 48 million barrels. If my mind was not prepared to the effect that it was all-inclusive committee that was indeed addressing the issue of whistleblowing. And if that is the case, I want to, I need your confirmation with precision arising from this sitting, so that I can now adequately prepare my mind going forward to address you collectively, generally, on all issues associated with whistleblowing. You are selective, you are particular, arising from the name of the committee, and your letter was selective and particular. And my response was accordingly selective and particular.
Okay, so, the Honorable Attorney General, I know that you can be a busy person. So maybe the members of your team who perused our communication did not advise you accordingly. Whenever we send, no, hold on, the House cannot name a committee beyond a certain limit. That is why you see that name is there. But when we communicate to you, we send you what is called the votes and proceedings of the House, which captures the resolutions of the House, which we expect whoever is receiving it to study. And it is in that votes and proceedings that you will see the resolutions of the House. The House was mandated to investigate so and so. We will give you a copy of that votes and proceedings now. It was very clear. And in the questions, a copy of which we have, the questions that were asked, specific to what we requested, which you also tried to respond to, showing that you didn't only limit it to the 48 million barrels. You also started to provide us with names of recoveries from whistleblowers and other sources, meaning that you also saw we asked the questions apart from the 48 million barrels too, sir. So let me just articulate that. So we did not restrict ourselves to 48 million barrels. In every circumstance, there's a limit to how you can name a committee. That's why in the wisdom of the House, they stopped where they stopped. But the practice of the House is to send you the votes and proceedings, which we'll look at and say, oh, their mandate also includes doing this and asking for this, which is why they are asking us for this information. So if that was studied carefully, you will see that that is why. And I can also assert that because of your submission about some recoveries here, that means whoever also assisted you in looking through it saw that there were questions about whistleblowing and whistleblowers and recoveries. That was also included in the questions. The questions are here, very detailed and specific to particular issues that were asked, which is why, sorry, General, I'll give you an opportunity to respond, no problem. Which is why we were wondering why your response, because in your response to the committee now, you've made it clear that you have assisted the country commendably to recover over $1 billion, but we cannot see $1 billion in this submission in terms of those recoveries as well. So which is why we asked for the details of the whistleblowers and the payments to them, because we know that these payments were made in line with the whistleblowing policy. And one of the things that we're trying to achieve from this committee's work is to come up with a proper legislative framework and proper legislation with regards to whistleblowing, so that it will become a statute in this country going forward. Because right now it's not backed by legislation, it's simply a policy of government, which you have a copy of, which indicates that they're supposed to be entitled to 5%. Is that correct, sir? 5%. No, you can respond by your mic, sir. Okay, so but the policy didn't very clearly state that. You have a copy. Can you refer us to that? In the policy we saw, it says 5%. No, sorry, you can put on your mic, sir. Sorry.
I am telling Mr. Chairman what often in practice, depending on the volume and size, we have had posts to negotiate as low as 2%, depending on the volume of the asset involved meant for recovery.
Okay, so we are saying that because we believe every policy should be backed by guidelines that should be sacrosanct, not at the whim of any party. So we're referring you to the copy of the policy that we have that indicates 5%. So if there was a proviso about 5 or less, then that's why I said if you can please show that to us, because we are not aware that there was a proviso. So because one of the questions we're going to ask is when we saw in some instances the payments that were said to have been made were less than 5%. So we were wondering, and then of course we'll still ask about the evidence of the remittance of these monies that were recovered, the evidence of the payment of this money. These are some of the things we actually already requested for in the document that was sent. So, Solicitor General, you wanted to say something before I continue?
Thank you very much, distinguished Chair. Perhaps what the Accountant General may have sent to this committee would have been a total, including from agencies like the Economics and Financial Crimes Commission, because they also handle whistleblowers as well. But what we sent to you was what we have in our records. And I think in the documentation which we provided, we also said we do not receive funds in the ministry. The Minister of Finance is the one who authorizes the Accountant General to open an account into which such recoveries are made. And when the whistleblower writes to us to say, you know, based on the information I provided, for instance, £1 million, just in case, for example, has been recorded, what we then do is to write to the AGF to confirm that indeed £1 million has been received. And then we will then review the case to see that the £1 million was as a result of the recovery effort or the information provided by the whistleblower. Now, the President had approved a cap of 10%, but sometimes when the money is a lot.
President approved a cap. So can we have the communication, the memo of that approval?
That is what was written into the whistleblower policy. And sir, I just would like to clarify.
No, but sorry, just before you, sorry, okay.
Sir, when a statute provides that an offender should be punished for a term of 5 years, the court is at liberty to give from 0 to 5. That's usually how it is calculated. So if we say you'll be entitled to 5%, and we say, by the time we calculate 5% of this is a lot. So would you take 2% or 2.5%? If they agree, and when they agree, that is committed into writing. It is that we recommend and to the Office of the Accountant General. We are not the ones who are making the payment. And for us, really, that's adding revenue to government. So if government was going to pay them $1 million and we're able to negotiate and pay them $500,000, then who has lost? Definitely not the federal government. They are at liberty at the beginning of the negotiation to say, we will not take anything less than 5%. But
so we quite understand that, you know, and that also informs the concern. Now look at it from the committee and the other Nigerians' point of view. If you negotiated it downwards, we want to be able to ascertain without accusing anybody that that is the entirety of the amount that was paid, that the balance of 2% was not paid to someone else, that the balance of 2%. Okay, sorry. Let me just conclude on that. And so that is part of why that's part of why we were mentioning the issue of the percentages that we saw that were paid and what the policy itself says. And as lawmakers, you can understand with us that for us, we usually say, and the person shall, you know, or may gives you that prerogative. Like the very learned Sikh knows there's a difference in law. Like you two also know as a very learned person, senior lawyer to yourself. When you say shall or may, they're totally very different, which is why I was asking for a referral to that provision that gives that latitude. We can understand what happens maybe in terms of a judgment, but we are talking about a policy that should drive how that operates. That's what we're talking to. Because, so we just wanted to emphasize this point before we go into the other questions we want to ask.
It's just, I think the concern should be if we allow a whistleblower to take more than the prescribed percentage. If we are able to negotiate a better deal for the federal government, and I think we should be commended for that. The truth is we do not have access to the account. Sometimes we have 2, 3 people engaged in respect of the same matter. And what we do, and what the Attorney General has always insisted on, is you split the 5%. Because if we continue to give each of you 5%, then government will be losing an additional 10%. So what we try to do is to get the best value for the federal government. So if we can get to give a whistleblower 3% or 2%, depending on the quantum, then obviously we'll save more money, so government retains more. That's really been the consideration for our negotiations and discussions with
which is appreciated and is commendable, of course. We do not expect to incur more costs for the government. Every qualifying recovery should be limited to that 5%. So if we can negotiate it within that, obviously, is acceptable. We are just trying to say that we just wanted to ascertain that no other aspect of that percentage was paid otherwise, and that was the conclusive settlement for that particular instance. So that is the point. And then with regards to what, sorry, Honorable General, you talk, sorry, sir. With regards to what you said, you see, the Accountant General, we believed, should have visibility of the transactions. And he said here in his submission that he's forwarding a schedule of whistleblower compensation as approved in the letter as per item 13, and he says that more comprehensive information with regard to whistleblower or recovery agents can better be obtained from the whistleblower unit of the Federal Ministry of Finance, Federal Ministry of Justice. You know, so I'm just trying to respond to you that, so they too were still referring us to you. Honorable General, sir, before we look at those questions, you were trying to say something earlier, so maybe you respond before we take up that issue of...
I was trying to give you a graphic picture of the whole process associated with the recoveries. Not necessarily whistleblowing, but recoveries generally. And that graphic picture started with the directives of the President for the opening of dedicated accounts for the recoveries. And dedicated accounts were indeed opened on the instruction of the President, which is contained in this bundle of documents, which is table 2, page 4 thereof. Yes, the last paragraph of it provides details of the accounts, asset recovery accounts that were opened. On the instruction of the President, by the Office of the Accountant General, in respect of which the Office of the Attorney General is not a signatory. I think it is important to get that clear. Accounts were opened. Now, proceeding further, next you find letter dated 8th February 2016. That letter is a letter of engagement. So if a whistleblower or perhaps a recovery agent came about with a proposal, we will provide the proposal to be sure whether there is merit in it and there is no conflict in instruction. And then we now generate letter of instruction. Next to the letter of instruction,
sorry, this letter of 8 February, this is a letter of instruction or engagement?
One of the recovery agents you have highlighted earlier.
So apart from the whistleblower, you engage somebody else to participate in the recovery or this Digbo is the whistleblower?
The terms of the committee you said are now expanded, not necessarily on the whistleblowing, but extended to recovery. And some of these items you refer to me were recovery agents. That is why I am now giving you a global picture of the way it operates. Now the engagement letter. Going forward, next 2-3 pages thereafter in the same bundle of documents, you find a power of attorney between the federal government of Nigeria and Oladipo Ofesheyi, conferring on him an authority to recover, to make recovery. And this relates to international recovery for that matter. So what I'm trying to say in essence, it is the embodiment of the letter of engagement, the agreement that will now give you a general and global picture of the terms of engagement. So whether 2%, 1%, 3%, 4% or 5%, the maximum is what is now agreed upon with the recovery agent, is usually contained in this bundle of documents comprising of the letter of engagement, comprising of the power of attorney, or perhaps any instrument of engagement. It is not done in the blues. So the idea of agreeing with a recovery agent on 3%, and then the Attorney General going back to take the 2% does not arise, because the terms as contained and agreed upon between the recovery agent and the federal government are spelled in black and white in the letter of engagement. So now, after eventually recovery is effected and lodged into any of these 3 accounts, if perhaps it is euro, payment is not in euro account, if naira into naira account, if USD into USD account, what happens? The recovery agent writes to the office of the Attorney General, intimating the Attorney General that we have indeed concluded on the recovery assignment given to us, and the recoveries were effected and lodged into account of the federal government, the recovery account number so, maintained with the central bank. Armed with the letter of the recovery agent, the Attorney General now writes to the governor of the central bank, please recall that we have engaged so agent for the recovery of so amount in so jurisdiction, pursuant to a letter dated so, a copy of which is attached. Now we are in receipt of a letter dated so from the recovery agent establishing that he had concluded on the assignment and the money is lodged into the federal government as a recovery account. Kindly confirm the receipt of these monies into the recovery account being maintained by the central bank. And the governor of central bank will now write to the Attorney General, I confirm that this money is received. A copy of statement of account establishing lodgement is attached for your consideration. And then, upon receipt of the letter, we now write to the Federal Ministry of Finance. Be informed that by a letter so date, we have engaged Difo Ofesheyi, for example, for the recovery of certain assets lodged or perhaps identified in U.S. Now be informed that those assets were eventually recovered, and then we received a letter to that effect from Difo Ofesheyi establishing same. A copy is attached. Be also informed that arising from the understanding he is entitled to 1%, as can be seen in the letter of engagement attached here, kindly process his payment of 1% if it is what is agreed upon. The Office of the Attorney General has concluded on its assignment. So the Ministry of Finance, the Office of the Accountant General will now rely on 1, the letter of engagement, 2, a letter of demand, 3, confirmation by the central bank, 4, letter from the Office of the Attorney General directing or requesting for payment, to now process payment into the account of the recovery agent. And the Attorney General has no hand in that process. And be further informed that the accounts, these 3 accounts we maintained, the Accountant General and Minister of Finance are by tradition the custodian of the federal government accounts, and the Attorney General has no hand in it. And again, arising from your appropriation law, if you may have to have further recourse to perhaps the 2022-2021 appropriation, you have a lying component of anticipated recoveries as being part of the appropriation of your law. And then the Minister of Finance now, armed with the appropriation law, evacuate this amount of money into the consolidated revenue account for expenditure. So that is the process for the purpose of highlight of the way the process operates and works. The idea, or perhaps the likely insinuation, of the Attorney General should changing the federal government. Now the policy says the ceiling is 5%, and then you are charging 1%, you are taking 4%, is not there. Why? Because the Attorney General is governed by by a letter, by a contractual agreement with the recovery agent, which spell 1%. So except, of course, if the Attorney General is going to undertake a new cycle, he does not have an opportunity of making a claim for a cent. The process and procedure is now regulated by POCA. Before now, what brought about the policy was the absence of legislation.
Precisely.
POCA has been pending in the National Assembly for over a period of 7 years before it was eventually passed into law by the 9th National Assembly. So, and the government was interested in having some level of transparency and accountability. That was what informed the decision of the policy pending when the POCA was passed.
Yes.
Now that the POCA is passed, the whole process is regulated by the provisions of Process of Crime Act.
Thank you. So which is all the passing of the bill, it was premised generally on the whistleblower policy. So that is what we just wanted to establish as well. So now, as much as we appreciate, like you have inferred, and we would want to request, like I did earlier, the Solicitor General mentioned the President had approved a cap of up to 10%. So maybe it was a slip of tongue on her part. 5%. Okay, so we would like for you to avail us, a copy of this approval by Mr. President. So, Secretariat, please take note of these details. We would also want to also have a copy of his instruction for the opening of separate accounts for these recoveries, because we believe that even as the President, he is not omniscient. He still needs to be intimated about statutory provisions. And like my colleague mentioned to you earlier, Section 162 of the Constitution is where we have issues with. These amounts that have been recovered, in our opinion, is a revenue to the Federation, to the government. And the statute, the Constitution, the grand norm says it should be paid into the Federation account, not into separate accounts. No, hold on, sir.
Mr.
Sorry.
Chairman, let me get you clear.
Okay, so
Please.
no, hold on.
It is a disbursement that must be made through, in line with the constitutional provisions I interpreted earlier. Disbursement of the federal government funds should be through the Federation account. It does not take away the idea of perhaps maybe separate accounts from which, for the purpose of transparency and accountability, deposits can be made and then evacuated for disbursement.
Okay,
that is the interpretation of the section. Don't bother yourself.
No, so that is something that we can also seek further legal interpretation of.
Please do. Go ahead.
Yes, because the Constitution here says, and it does not talk of disbursement. It says, the Federation shall maintain a special account to be called the Federation account, into which shall be paid all revenues collected by the government of the Federation, except the proceeds from the personal income tax of the personnel of the Armed Forces of the Federation, the Nigeria Police Force, the Ministry of the Department of Government charged with responsibility for foreign affairs, and residents of the Federal Capital Territory, Abuja. So, no, no, you see that interpretation, like I said, we will probably further seek that interpretation, because that to us implies trying to create an interpretation that the crafters of the Constitution did not intend from the beginning. The crafters, in our own understanding, as lawmakers, believed from wherever those funds are coming from, they should be paid into the Federation account. They should not be paid into an account, then sent into the Federation account after the fact.
The framers and drafters of the Constitution are not anticipating impossibilities. Now, let us take, for example, the value-added tax, which is a law that has been established passed by the National Assembly. Are you, in essence, by this interpretation, insinuating that nobody can do whatever reduction is made by a hotel, for example, if you are talking of the transport, from the customer, it must go direct into the Federation account? You cannot interpret the law to create impossibility. And by such interpretation, which is limited in context, in meaning, and in implication, you are now creating an impossibility. But the essence is, if the money is lodged into the account of the transport, is it eventually, if it is meant for the Federation account, transmitted into the institution responsible for ensuring at the end of the day that it gets into the into the Federation account? And the answer is yes. For example, now, the issue that may be of interest to you is whether the money lodged into this account eventually finds its way into the Federation account or not.
We're coming there. Yeah, we're coming there too, sir. Now, in the instance or case in which you referred to, which is open to conjecture, for instance, we are also privy to payments that are usually made through remitter into government coffers, into government accounts. So it is not impossible, because note that this law was made several years before certain advancements in banking, and certain advancements and certain laws were put in place, including the VAT Act as well. So it is not impossible for it to also envisage that even in that regard, people can make those transfers directly because of advancements in banking, in fintech, to be able to do that.
All right. Is it a Federation account, going direct into the Federation account?
So that
when
is
you
why,
talk of remitter,
that's why we're saying that
it's a collection point.
It's part of the concern. It's part of the concern we're trying to express.
So please address that concern legislatively. It's indeed a collection point. And then as a collection point, if it gets to remitter account, it is eventually evacuated into the Federation account. But for the purpose of reconciliation, for the purpose of establishing any wrongdoings associated with lodgement or otherwise, the account you require to now conduct the reconciliation process is the remitter account. The TSA2 in its own right, TSA account, is a collection point. At the end of the day, whatever gets in there eventually is evacuated into the Federation account. Federation account is the designation. Associated accounts are indeed the collection points. That is the way it goes. That is the way it operates. The Constitution is not to be interpreted in such a way that it establishes or created impossibility, because the central bank, for example, is not it's not a bank meant to serve individual customers. It is a bank of the government. So, however much you now desire as an individual to go to central bank and lodge directly ₦1 into the Ferragam account at the central bank, the same way and manner you do with the commercial bank, you do it. Even as it relates to the deductions on your case, have you ever been to the central bank to lodge deductions on certain taxes related to your personality? It's not the way it is done, Mr. Chairman. Sorry about it.
These are things that we still have to look at based on the original intendment of the law. Now, if it is what has been practiced and what has been the process, then how do we bring our laws in conformity to the prevailing circumstances? These are things that arise from engagements of this sort over these matters. But we, as the legislature, we're just communicating to you what we perceive the statutes say in that regard. Now, with regards to the actual payments of monies from these recoveries, we would want you to please provide us with the statements of accounts for these accounts for the period under review. For each of these accounts, and like we said previously, because I had indicated previously that the details of the recoveries you provided in Table 2, some of what was provided by the Accountant General was not contained there, which leaves us to believe there are other recoveries too that are not here. So we would want you to please provide us with details of all the recoveries as was requested for in our initial correspondence. Then in that regard too, we would also appreciating, of course, your position as not being the custodians of those accounts, but you have taken us through a process of the document trail before any payments are made, to also provide us with copies in each instance of these recoveries and whistleblower settlements of that correspondence, your engagement. Because for Dipo or Sheyi and Co. to be engaged, that means it is either them or somebody else that brought to your knowledge the existence of certain resources that belong to the federal government at a particular location that you're seeking recovery of. Either that or the Attorney General's office on its own identified somebody who they felt they wanted to utilize to recover those funds. This is the clarification that we would also like for you to provide for us, but we want you to provide for us too the documentation in each instance of these recoveries indicating who made the recovery, how much was recovered, the account it was paid into, how much was paid to the person, and then your letter of engagement. Your letter of engagement. Your letter of engagement and your communication with the CBN, the CBN's response, and your communication with the Ministry of Finance.
Maybe
Yes.
by way of assisting you further,
Yes, sir.
from my earlier submission.
Yes.
This is a copy of the confirmation of receipt by the Central Bank. It's in, I don't know whether to take it.
No, we have seen that. We have seen that.
Okay.
That's why we said provide that for us.
So what I suggest
Yes.
would be a better and tidy approach for you in terms of covering the bill as far as investigation oversight, the investigative oversight is concerned. It's perhaps for you to write to the Office of the Accountant General to avail you with the asset recovery accounts generally maintained by the federal government. To write to the Governor of the Central Bank to avail you with the accounts, asset recovery accounts maintained by the Central Bank, and if possible, the statement of accounts. Because the only thing that is available at the disposal of the Office of the Attorney General is perhaps the confirmation of receipt of the lodgement made by a recovery agent, issued to us by the Central Bank, often claimed by a recovery agent that he has concluded on his assignment and the money is lost.
Yes.
It is not within the statutory functions of the Office of the Attorney General to be a custodian of an account, much less of providing incidental statements associated with it. The functions is the function of the Office of the Accountant General Ministry of Finance and the Central Bank.
So perhaps
the
AG, sir.
Arising from the contentions and submissions of the Attorney General, you can take the Office of the Attorney General up on discrepancies if any claim is not substantiated arising from the entries in the asset recovery account of the federal government. But what the Office of the Attorney General can provide you is indeed confirmation of correspondence with the Central Bank and the Accountant General. Central Bank confirming the receipt, Accountant General instruction that payment should be effected.
So
anything associated with the account, the opening aspect of it, Finance and Accountant General. The custody and maintenance of it, the Central Bank. Correspondence and confirmation.
So we thank you very much, the AG, sir.
Thank you.
We're quite aware
Yes.
of and do not need to be educated
Okay, sorry
on
about
the functionality about that. We showed you a document from the Accountant General's office earlier.
Yes.
Maybe we should show you the one from the CBN
Yes.
as well. So we are quite aware, and relevant correspondence will be sent to those. So if you make clarifications in that regard, we are very privy to the relevant details of the operation of each office.
Thank you.
And we thank you very much for that. So the information we have requested from you also is with regards to these recoveries and this whistleblower recoveries as well, because I'm trying to separate them now, because some you tag recoveries, some you tag from whistleblowing.
Yes.
In both instances, they were all premised under the whistleblower policy. That is how they were being settled. So we want you to provide us with the details, any outstanding of such recoveries, including this correspondence, like you rightly pointed out, your engagement, your communication with the CBN of confirmation, their response to you, and your correspondence with the Ministry of Finance. The Minister of Finance herself, too, is supposed to be coming before the committee today, and we're still hoping that she'll make an appearance before we conclude today's investigation. So this is information that we would appreciate that you provide us with. And, okay, sorry, you still have something to say, because we don't want to keep...
If you look at Table 2, sir, which is details of whistleblowers, we try to provide some information. So I wish to be well guided as to what additional documentation we need to provide. What we tried to do was to provide the Honorable Committee with a paper trail. So if in some cases you would have a letter from us.
Okay, so in order, sorry, I understand your question, so that we can, move very quickly.
Yes, sir.
And engage
if
other
you see a letter
people.
of May 4th, it's confirmation of receipt of funds from the CBN to
No,
us.
we are aware of that.
Yes.
I gave you a letter, a submission from our Accountant General. Some of the people the Attorney General confirmed he was aware of are not on the list of 9 people you sent to us. So that leaves us, that leaves us to believe that there are outstanding recoveries that have not been provided to us. So one of the things we are requesting for is that any outstanding recoveries that have not been captured, we do not believe it is only 9 recoveries that amount to the billions that the Honorable Attorney General has said his office has very patriotically recovered for Nigeria. So we're saying that anything outstanding should still be provided to the committee, and then in that regard, alongside that and including these 9, should be the documentation for in each of those instances, because he took us through the process. There's a letter of engagement, there's a letter to the CBN confirming the recovery, there's a letter from the CBN confirming receipt, there's a letter to Finance advising payment. So in each instance, we would want you to provide us with that information. That is very simply what we're saying.
Based on the list which was forwarded by the Office of the Accountant General, sir?
No. based on the entirety of the recoveries that you have made on behalf of the federal government,
Sir, I think that
including what the Accountant General in his letter, like I read to you, was still referring us to you that you are the ones who are custodians of that information, that he got that information from you.
Sir, with due respect, sir, it's like asking me how much money I lodged in the bank. The bank is the best person to tell you what my lodgements are. Because the banks are,
no, because you initiate, no, in this regard, no, I beg to differ. In this situation, you initiate the recoveries. The Honorable Attorney General told us this. You initiate it, you engage,
the Accountant General is the best person
you have that agreement.
Being the recipient of all recoveries to tell this committee.
No. So the committee.
Because whatever we are telling you, we do not receive.
We are not talking about the resources and the funds alone now. We're talking about the processes that lead to the actual receipt and lodgement of the funds. That is what we're referring to now, which you have already provided some of here. So the same thing you provided us here, we're simply saying any outstanding you have not provided, provide them for us.
I get that. It's just that they also have everything.
No, but we're requesting.
Because they would never release dime without proper documentation.
So
what
General,
the request from you is give us the letter of engagement, give us the agreement, proof that the funds have been paid, the recovered proceeds have been paid into CBN. All of that.
But this is the difference.
They then do the calculation of what 2%.
So General, please. I don't want to start to rule you out of order, please. We have made it clear that your office is the originator of the process towards recovery. That much has been established. And this is correspondence that more times you are the one who generates to CBN, confirm receipt. CBN responds to you. We have confirmed receipt. Then you write to finance. These are documents you generate. Those are the documents we are requesting for. We're not going to ask Accountant General to give those documents to us. We would want you to give those documents to us in that instance. We, like the Attorney General pointed out, know what we will request from the Accountant General and the CBN to give us that have to do with the funds and have to do with those accounts. And that is what we're requesting for, please. Thank you very much. The two final issues before we let the Honorable Attorney General leave. This one too borders on whistleblowing, both of them. The first one, the NFIU CEO was here, but he seemed to be indisposed, so we engaged with him. Unfortunately, he was not here. We wanted him to be here when we discussed this issue, but he's indisposed. He will meet with us at a later date. Okay, it has to do with the Paris Club refund and the fact that, bring the statement from the account, please, from the bank. Two companies, GSCL Consulting Services Limited and BizPlus, also Consulting Services Limited, were each paid 16 billion into their accounts, and it is something that generated some concern in certain quarters. This whistleblower actually made a report formally to the NFIU about this, and we have not received from the NFIU any formal report of what investigation they carried out. We hear the issue was referred to some other quarters for investigation. We're still waiting for the EFCC to also give us their report on this particular matter. But the bank graciously gave us the account statements to confirm that indeed, and interestingly, Attorney General, I will interest you to know that these accounts for both companies were opened at the same period, within the same period. We will avail you these details as well. within the same period. This payment was done at the same time, and the monies were paid out of these accounts within a few days, and then those accounts became inoperational. So meaning it was as if this was a special purpose vehicle made to receive 16 billion each from the refunds to the Federation. So it is important for us as the Attorney General, because your office, now I wouldn't say your name now, your office came up as one of those involved in that transaction, and it's a few other individuals, one of whom has been elected into the House of Reps now, being involved in this entire transaction. So we would want your feedback in this regard, with regards to this transaction, because we also requested for whether you were privy to any agreement they had either with the federal government or with the state governments to provide these services. We wanted to have copies of such agreements that entitle them to this payment. On what basis was that amount of the Paris Club refund to the Federation paid to those two companies? Please give us some clarification, sir.
By way of clarification, one thing I can say with precision and certainty is the fact that in all matters or issues associated with Paris Club in the office of the Attorney General, these companies you are talking about do not ring bell as being part and parcel of the companies that we had forced to directly deal with. But then for the purpose of referrals, I will refer you to...
Okay, so first of all, sir, just for clarity,
yes,
you are not familiar with these two companies?
No, I will give you insinuations,
okay,
not certainties.
Okay.
Insinuations, not certainties.
Okay.
So the office, one certainty I can tell you about it is we had no cause whatsoever in the office of the Attorney General to deal with these companies at all. But then the cost of trying to sort out issues relating to Paris Club, for example, because it is an issue that has a checkered history. Judgments relating to Paris Club and cases relating thereto, some of which are listed at serial item number 5 in table 1E, were inherited. A lot of judgments, a lot of orders, counter orders, claim and counter claims were inherited by this government as of 2015 when we came in place. Table 1A, item 5, is it? The page, okay, page 6 to 7 of 1A. Okay. This is table 2, table 3, and 1A. Just 1 minute, sir. Okay, okay, so this paper is 1A. Okay, I take you to page 6 of 8 and then page 7 of 8.
Okay, page 6 of 8
and page 7 of 8.
Yes.
Page 7 and 8 down to page 8 of 8 gives you an idea of the numerous cases pending, I'm talking of the pending cases relating to Paris Club that are pending in court. What I'm trying to establish arising from reference to this number of cases is the matter related to Paris Club is indeed not only a matter of checkered history, but indeed a matter that is sub judice as of today. But notwithstanding, and at the risk of perhaps operating outside the boundaries and limits of the sub judice principle, I will still, in the interest of investigative support for the committee, provide some insight. These two companies, GCNL you said, and whichever?
GSCL and Biz Plus.
And Biz Plus.
Yes.
throughout our engagement as a ministry, we have never had cause whatsoever to deal with them directly or indirectly, arising from our engagement or instructions, or perhaps anything that has to do with brokering any understanding with them. But one thing I can tell you, when we came on board as a government, the Paris Club kept a kind of coming up in terms of contentions, with multiple cases, threats at enforcement on the asset of the federal government, over judgment, arbitral awards, and indeed settlements that had been concluded even before we came on board as a government. So it became a source of concern because a lot of apprehensions day in, day out on the federal government asset. So I was instructed by the President to look at the possibility of bringing a closure to issues relating to Paris Club. And Mr. President approved 350 or 60, I can't remember with precision, $1 million for the purpose of using same and bringing a composite settlement and closure to the issue. And Mr. President directed, if arising from our settlement, we succeed in having any, perhaps, balance unexhausted, it should be paid back to the Governor's Forum, because all the judgments, all the cases were against Governor's Forum and ALGO, local government, what is called, Association of Local Government. So we now embark as a ministry in an effort to negotiate. We succeeded substantially in negotiating most of these judgments by way of having them settled. But there were some that were very stubborn that refused to allow for any compromise over the judgment sum they were contesting. And then there was a balance. In line with the instruction, I can't remember the amount of the balance then, but in line with the instruction of the President that if eventually there was any outstanding balance, it should be paid back to the Governor's Forum, at whose instance Mr. President was prompted to act. After the conclusion, we now wrote, because the funds were in custody of the central bank, we wrote a letter to the central bank notifying the central bank of the fact that settlement has been reached in respect of these cases substantially, but no settlement has been reached in respect of this number of cases. And the President has directed that in case there is any balance outstanding after the consummation of the settlement, that balance should be paid to the Governor's Forum. So kindly reach out to Governor's Forum for direction as to the account into which this outstanding balance should be paid. That was it as far as the Federal Ministry of Justice is concerned. Now, talking of the insinuations, I am not in a position to say...
Sorry, sir, before you continue, just so that we follow you, sir.
Yes.
So, with regards to these settlements, the President approved for you to have, so you have that correspondence,
yes,
available to make available to the committee.
We do.
Okay, so would like for you to make that available to us.
Okay.
And then, in terms of that engagement, you don't recall any settlement between you, any settlement conversation or negotiation you had with Biz Plus and GSCL?
Not a single. No, I am certain that Biz Plus and GSCL was never ever engaged by the Office of the Attorney General as far as negotiation is concerned, because at any rate, they were not part of the cases that we were considering in terms of settlement. Was there any case related to them that we negotiated on? So they were not indeed parties to the Paris Club settlement arrangement that we were asked to settle. So we had no force whatsoever to engage them. So perhaps, maybe, I am not sure, by way of insinuation, as I stated, maybe at the point of transmitting of the balance to the Governor's Forum, they may be factored in one way or the other, I'm not in a position to say with clarity.
Okay, sir, because the amount transferred to both accounts amounts to about $50 million or so, thereabouts. And so that is much less than what Mr. President approved from what you said. So we will...
It was the balance after settlement that was supposed to now be dealt with. So certainly the balance will be very much less, because there was some of the Paris Club contestants, I mean those that have pending cases, that were engaged in negotiation, and then
was the balance up to $50 million?
I can't remember with precision, honestly. But I am certain there was a balance, and I am certain we wrote a letter to the governor of the central bank intimating him of the approval of the president that outstanding balance should be now paid into the, to the governor's forum.
So no problem. So we appreciate very much this clarification you are giving us, and so in furtherance of this cooperation you are giving us, please let us have an idea of that balance, because that balance that was left.
Okay. I believe maybe arising from the correspondence with the central bank after conclusion of the settlement, you will find the figures contained therein.
Because we're okay. So because we will also await the response from the CBN, because the bank statement clearly shows this payment was made from the CBN.
Sorry?
So the bank statement from those companies.
By insinuation, I'm not certain even in that respect. Maybe
no. I have it here to show you. These are the statements, the bank statements from the bank.
Oh, okay.
I said we will avail you a copy of this.
Okay.
It shows clearly 16 billion.
Yes. What I'm telling you with precision is we did not, as the Office of the Attorney General, deal with those companies at all.
Okay.
Yes. So
no problem. We appreciate your feedback. We'll also await the CBN's confirmation and clarification.
Yes.
But we also just want to appreciate your feedback on what the balance was, so we have an idea, because
yes. I believe our correspondence to the central bank
will be able to give us contain. Okay, fine. So we'll just like to, we'll appreciate having that. So finally, now there is information at our disposal, corroborated by the Indian High Commission, that certain individuals in this country, and again, the office of the Attorney General, not Alaji Malami, was said to have prevented the Indian government from the extradition of some individuals who have been given very, in the words of Nigerians, juicy oil and gas contracts in Nigeria. The owners of the Sterling Group, Nitin Sandesara, Chetan Kumar Sandesara, his wife and brother, the Indian High Commission, we have a copy of the letter from them here, have confirmed that these individuals are fugitives from their country because of the fact that they defrauded banks for billions of dollars, and that they were informed they are taking refuge in Nigeria. But when that request was made to the Nigerian authorities, we always were concerned that the Attorney General said this was politically motivated. So you refused to honor that extradition request, even though we have treaties with them, and even though there are United Nations conventions in this regard. And what informs the concern for us as well is the fact that we are also aware this same company is now the operator of the Kolmani field. There's some other oil and gas contracts, drilling wells in, like my colleague said, in Kwale and other places. So we do not understand how the Nigerian government will be shielding these individuals and allowing them to do business. We can also avail you a copy of this correspondence, where they have very clearly advised that it was the Indian government's desire for these individuals not to be allowed to be given any kind of status here. We are hearing, we are not certain about this, that they now have Nigerian passports. They're now allowed to thrive and do business here when they are wanted in their own country in this purpose. So we would also want you to provide clarification for us, because like we said, like I pointed out on the onset, the National Assembly does not just engage in a wild goose chase. Yes. We have a document from the Indian High Commission corroborating this whistleblower's allegations, which the Nigerian public is not even aware of until this information came to the fore. Yes. That there are individuals like that thriving, being given choice contracts, and yet they are on the run from their country, India. Yes. So we would want some clarification about this, sir.
When you talk of Indian High Commission, as far as correspondent is concerned, the undertones associated with it are diplomatic. And unfortunately, extradition is a judicial matter. It's an issue that involves conflict of laws. And with that background in mind, my conclusion is the Indian High Commission correspondence is not actionable as far as my reaction is concerned, but I would suggest to the committee that the committee may consider perhaps writing a formal request to the Office of the Attorney General so that we can now factor in the effective response.
Sir,
hold on. I'm talking about, give me the copy of the letter to the Attorney General, please.
Yes, sir. We do not have an official copy of that letter. And I think that it would be mischievous for diplomatic correspondence to be between a government and our National Assembly. That's undermining our integrity as a nation. And I would believe that if such correspondence was received by the National Assembly, it should have been forwarded to us. I don't know, did it come through the Ministry of Foreign Affairs? We didn't get anything, sir. And so we're talking about political undertones. So it's very important that we get, letters must come through proper custody, sir, please. We don't have it as a letter. If we had it, we would respond legally to the issue. We are not responsible for giving oil contracts, so we are not able to speak to those issues. So it's very important if we get the letter, then we'll respond appropriately. But I think that we're not expecting this. We didn't come prepared for this. We do not, the Office of the Attorney General is not responsible for some of these things that they may have said or they may have alleged. So I would really plead that we get formal correspondence. We'll work with the Ministry of Foreign Affairs and we will respond appropriately.
Now, what was communicated to you by the committee specific to this?
Let's see, and evidence of receipt, please.
Okay, so in regards to the other question you said, yes, it came through the necessary quarters, which is why, because we made that communication to them to confirm certain details.
Okay, please, Mr. Chairman.
And, you know, we were asking you not with regards to whether you are the ones awarding oil contracts. We're asking you with regards specifically to the issue of the extradition that was said to have been denied because of political reasons.
At any rate, even in our own case as a ministry, when we receive a request of this nature of extradition, it's something we file through judicial process to obtain necessary judicial orders for extradition. And then there are standards in terms of compliances and expectations in support of the application. Once you do not have those elements complied with or established, there is no way you can initiate the judicial process. So at any rate, my suggestion, in line with the submission of the Solicitor General, is for the committee, in line with the established tradition of sending to us a formal request developing issues, to consider that possibility so that issues can now be effectively joined for the guidance of the investigative committee. Thank you.
The correspondence for clarity specific to this issue will be sent through the relevant channels and in the manner you require immediately. because our own concern is not about the judicial process. We're asking information. That is strictly what we're not participating in the process. We're getting information because we handle treaties that we have with other clients. We are concerned about our transparency index, about UN conventions that we superintend in some regard. So we are concerned because we too might have need in future to make a request of that government, which we have had cause to do previously.
I've responded to uncountable extradition requests by India and other jurisdictions. But the condition precedent is compliance with the process. For example, Mr. Chairman, political persecution does not allow for extradition internationally. So
Yeah,
if for any
know,
reason now, I don't know.
We have the law with us.
Yes, so,
We have
so
that,
if,
so-
for example,
so-
that as the element is established arising from the application, no court will grant it.
Tuesday next week at the latest. No, he has already said. He has already said
As a
he's
private person.
willing. It is the.
No, I've seen his ticket. He's going to the US or something.
Okay. Thank you very much, sir. We appreciate your audience, and thank you very much for coming. And you may take your leave, sir. Thank you.